It's 1963 and Halloween night in Cleveland, Ohio. John Terry and Richard Chilton are pacing back and forth, stopping and looking inside a closed store's window. Detective Martin McFadden sees them and thinks they look suspicious. So McFadden approaches them, frisks them, and finds 2 pistols. Terry and Chilton are charged with carrying concealed weapons. At the trial, the defense wanted to exclude the weapons on the grounds that their search and seizure were wrong. Funny enough, that question is still relevant today. When is it legal for police to search and seize my property or me? So this is where it gets interesting. The case, Terry v. Ohio, went all the way to the Supreme Court. The court sided with the officer. They agreed it was totally okay for the officer to have stopped those guys. They were acting suspiciously. But this was surprising because it seemed to go against the Fourth Amendment, which states that an officer needs a search warrant to search or seize anything, whether on the street or in your home. Before we get ahead of ourselves, let's talk about why the founders wanted to limit authorities' power to search and seize. In the 1700s, the British used documents called writs of assistance to search people's property to see if they had any untaxed goods. The documents were essentially a free pass that allowed British authorities to search anybody's property at any time. The British were calling it smuggling. The colonists were calling it taxation without representation. After the dust cleared from the American Revolution, the founders were writing the Constitution and included the Fourth Amendment to protect citizens from government overreach. So the Fourth Amendment protects us from unreasonable searches and says that warrants can only be issued with probable cause. But when is a cause probable?
There's unfortunately not a super clear answer to that question.
We talked to a civil rights lawyer, Catherine Hubbard, about probable cause.
It's an officer's reasonable belief, based on the circumstances known to that officer, that a crime has occurred or is about to occur.
So probable cause is when an officer believes something is about to go down. They have to prove it to get a search warrant. To obtain a search warrant, an officer submits a warrant application to a magistrate. In the application, the officer has to define why the place should be searched, be specific about what they're looking for and where they will look, and swear that it's all true. Then the magistrate reviews the application and decides whether or not to grant the warrant. That sounds good to me. But police officers kept finding themselves in situations where they wouldn't have time to get a warrant, just like what happened in Cleveland with Terry and Chilton. In that case, Terry v. Ohio, judges acknowledged the realities of police work and allowed police to stop and search people based only on a new standard called reasonable suspicion. Okay, so what's reasonable suspicion?
It has to involve an officer having a reasonable, articulable suspicion that some sort of criminal activity either has happened or is ongoing. We haven't gotten a ton of guidance from the Supreme Court on what exactly that means, but they have said it has to be more than a hunch.
Well, I would hope so. I have hunches all the time, and they're usually wrong. Wait, yeah, they're wrong all the time. It makes sense to me to give police officers discretion to make decisions on the fly without going to a judge. But police discretion can easily turn into police power, which can turn into government overreach. That thing our founders are trying to avoid in the Fourth Amendment. Turns out, Terry v. Ohio and reasonable suspicion affected search and seizure laws in a major way.
The Supreme Court ended up holding that where an officer observes unusual conduct that leads the officer to believe that some sort of criminal activity is afoot, he is entitled to use the suspect and conduct a limited search. And so Terry contained all these seeds that eventually grew into the modern stop and frisk doctrine.
Stop and frisk. When an officer has reasonable suspicion that a suspect was committing, is committing, or is about to commit a crime, stops that suspect and frisks them to determine if they are carrying a weapon. Stop and frisk is a police tactic used around the country and was particularly prevalent in New York City. Here are some stats from the program at its height in 2011. Police made almost 700,000 stops. 53% of those people stopped were Black, 34% were Latinx, and only 9% were white. 88% were found to be totally innocent. Those percentages were similar for each of the 15 years the program was in action. That's a lot of innocent people. Police officers were told by their superiors to stop the right people, meaning Black and Hispanic men, because police believed that they were committing the majority of the crimes in New York. Later, statisticians proved this hunch to be false. In 2013, a judge in the federal district court in Manhattan ruled that the methods used in New York were unconstitutional. The judge stated that the NYPD's interpretation of reasonable suspicion was a policy of indirect racial profiling and was therefore a violation of the Constitution. The Constitution prohibits enforcing the law based on someone's race or national origin. Terry v. Ohio opened the door for stop and frisk policies. The outcome afforded police more freedom to do their jobs, but as we saw in New York, that freedom is open to interpretation. Police are still using stop and frisk around the country. Is stop and frisk a violation of the Fourth Amendment? How can we design a system that protects citizens' privacy while still allowing the police to find and fight crime? So, what do you think?